This trial altered the course of history. For the purpose of this list, we will be examining landmark lawsuits and trials that took place in the United States and were surrounded by controversy owing to the nature of the case. Number 10. United States v. Nixon, 1974. The previous president of the United States, Richard Nixon, was embroiled in one of the most significant political scandals in the country. In an effort to acquire influence for the forthcoming election, 5 men were arrested after they attempted to force their way into the headquarters of the Democratic National Committee in Washington, District of Columbia. It was Nixon who brought the case to trial when the appointed special prosecutor issued a subpoena for tapes and documents that linked him to the crime. As a result of the judge's refusal to grant the request to dismiss the subpoena, Nixon was forced to appeal the decision to the Supreme Court. The attorney for Nixon presented a number of arguments, one of which was executive privilege, in an effort to persuade the court to refrain from compelling the release of evidence. It was unsuccessful. Nixon was given the order to hand up everything, which ultimately resulted in his incrimination and finally led to his resignation. Number 9. State v. Norman, 1988. If you hear the term self-defense, the first thing that often comes to mind is some kind of action that you take to protect yourself in the event that you are subjected to an unwanted attack. On the other hand, what are your options if you have been harmed on multiple occasions and have made the decision to take action before it happens again? According to Judy Norman, this was the primary subject of a case that took place in North Carolina. Norman had finally had enough of her husband's alleged maltreatment over the course of several years, and she decided to take his life while he was sleeping. Given the extensive history of both mental and physical abuse, she defended herself by claiming that she was acting in self-defense when she was charged with the crime. The court finally decided that Judy was guilty of voluntary manslaughter, since it was determined that a claim of self-defense could not be brought because the defendant was not in imminent fear of significant bodily damage or death. Number 8. Obergefell v. Hodges, 2015. Jim Obergefell and John Arthur, his partner, tied the knot in the state of Maryland, which allows for marriages between people of the same gender. However, because they were residents of Ohio, a state in which such a marriage is not legal, the state would not acknowledge their newly acquired marital status. They challenged the law, arguing that the prohibition on marriages between people of the same gender was discriminatory. Due to the fact that John Arthur had passed away in 2013, Obergefell decided to take the matter all the way to the Supreme Court after losing a court battle with the state. The case shed light on the various perspectives that people hold regarding the question of who should be allowed to receive the right to marry. The court decided in favor of Jim and issued an order that all 50 states should accept marriages between people of the same gender in the same manner as weddings between spouses of the opposite sex are recognized. Number 7. The State of Tennessee v. John Thomas Scopes, 1925. This case, which was given the nickname Scopes Monkey Trial, was brought before the court without any wrongdoing having been committed. In the year 1925, the American Civil Liberties Union had the intention of challenging a state legislation in Tennessee that prohibited the teaching of evolution in educational institutions. Following the agreement of John Scopes, a local science teacher, to take the role of the defendant, a trial was held. A high-profile prosecutor, William Jennings Bryan, who had previously served as Secretary of State, and the contentious issue of creationism against evolution were the two factors that brought it to the attention of the whole nation. Although the American Civil Liberties Union, ACLU, was unsuccessful in both the case and the appeals, it was successful in bringing about a wave of awareness regarding the teaching of modern science in classrooms. Number 6. Bush v. Gore, 2000. In the presidential election that took place in the United States in the year 2000, George W. Bush won the state of Florida by a margin of less than 2,000 votes, which resulted in an automatic recount for certain counties. As a result of the fact that some of them were unable to meet the deadline for submitting their updated counts, the Supreme Court of Florida ordered a recount across the whole state. Worried that it might cause him to lose the election, Bush filed a lawsuit against the ruling with the Supreme Court of the United States in the hopes of preventing the ballots from being counted once more. Gore had already won the popular vote, but in order to become president, both candidates needed to win the Republican primary in Florida. Regarding the manner in which votes are counted, the utilization of punch cards for voting, and, of course, the question of who would finally be elected president, the case garnered national interest. At the end of the day, the Supreme Court decided in favor of Bush, which eliminated any possibility of John Gore winning the election. Number 5. State of Florida v. George Zimmerman, 2013. Following the shooting death of African-American Trayvon Martin, which occurred following an alleged confrontation in the beginning of 2012, George Zimmerman was charged with murder. It was unclear whether Zimmerman was acting in self-defense or whether he had targeted Martin because of his background. This was the central question that surrounded the trial. The general public had the impression that it was yet another instance of a white man attacking a black person for no other reason than the fact that he was that person's race. One of the events that led to the beginning of the Black Lives Matter movement was the verdict that found Zimmerman not guilty. People gathered together to voice their disapproval of occurrences involving the abuse of people of color, citing Martin's death as yet another example of such a senseless incident. Number 4. Casey Anthony, 2011. Kaylee Anthony's body was discovered close to her residence and was discovered after her grandmother reported that she had gone missing. Due to the fact that she gave incorrect and contradictory information on the whereabouts of her daughter, Casey, the mother, was charged with first-degree murder. There was a large amount of physical evidence that suggested that Casey was guilty. Nonetheless, the jury were able to form sufficient doubts that led to her being exonerated of all counts related to murder and found guilty of misleading the authorities. The probe received an enormous amount of coverage from the media, comparable to that of the trial of O.J. Simpson. The general public had the impression that Casey wanted to escape the role of a parent and had accomplished this by engaging in acts that were incomprehensible. Number 3. The people of the state of California v. Orenthal James Simpson, 1995. O.J. Simpson was accused of killing his ex-wife Nicole Brown and her friend Ron Goldman, and the trial that took place between the people and Simpson was possibly one of the most publicized trials in the history of the United States. Everything about this case was kept under wraps, from the notorious white Bronco chase to the glove that didn't fit properly. There was nothing that was kept hidden from public view. As a consequence of this, the public's feelings regarding Simpson's guilt appeared to be divided along racial lines. This, in conjunction with the physical evidence that was shown, as well as the inventive use of catchphrases by Simpson's attorneys, gave viewers with a tremendous amount of material to hold their attention. It came to a conclusion in October of 1995, when the verdict of not guilty was announced for Simpson, which was seen by 100 million people. Number 2. Chelsea Manning Trial, 2013. When people think of people who have leaked secret information, Edward Snowden is often the first person that comes to mind. On the other hand, intelligence analyst Chelsea Manning started leaking critical documents, films, and other materials to the website WikiLeaks in the year 2010. These materials included information about both the Iraq War and the Afghan War. She read a statement that indicated the disclosures were aimed to show the true cost of war, when she entered a guilty plea to 10 of the 22 offenses in February of 2013. Contrary to what the general public had been told about the wars, the details concerning the conflicts that were discovered in the records that were released provided a striking contrast. Number 1. Roe v. Wade, 1973. In the year 1969, Norm McCorvey, also known as Jane Roe, had the desire to terminate her pregnancy. However, she was unable to do so because of a legislation in her state of Texas that prohibited abortions. Due to her conviction that the laws violated the Constitution, she filed a lawsuit against the state and ultimately prevailed. Despite the fact that the landmark case established a precedent for abortion legislation across the United States, it has also been challenged on multiple occasions in a variety of contexts since it was decided. Additionally, it essentially sparked a dispute that has been going on for a long time between proponents for pro-life and pro-choice. Roe v. Wade is once again in the spotlight as a result of the passage of the Texas Heartbeat Act in 2021. Many people are concerned in how the events brought about by this new statute will alter the effectiveness of the decision that was made in 1973 over abortion. Share your opinions with us in the comment below, and subscribe now for more videos like this.